Welcome to The Responsible Citizen, and I'm your host, Ayebelam Anthony. And on today's show, we are honored to have Mr. Ssemwanga FREDRICK, Legal Counsel, Parliamentary Liaison, Uganda Episcopal Conference. We are here to talk about the issue of wills, that topic that keeps coming up on people's minds. So, Mr. FREDRICK, what is a will? What does someone need to know about it?
First of all, a will is, I'll give a legal definition. It is a testamentary disposition of what someone wants to happen after his death. A will is a document which someone writes, including information regarding what should take place in case he's dead. That is a will. So the law provides for two types of wills. There is an oral will and then a written will. A written will is one which is reduced in writing. Then an oral will is not written. You come and tell me what you want, but it has time limit within which it can apply. It is applicable only within 1 month. So the law requires that if you talk about a will, you must have your will written. So you cannot say I left a will if it is not written anywhere. So a will must be written, must be reduced in writing. It doesn't matter the language you use to write a will, as long as it is a written document giving the details of what you want to happen after your demise.
So who can write a will? Can an ordinary person write a will, or should I reach out to a lawyer? Help us understand that.
Yeah, first of all, any person who is 18 years and above is free to make a will. As long as you are 18 years and above, you can make a will. But in terms of preparation, you can sit down and write your own will. You may not need a lawyer. If you want a lawyer, you can use a lawyer, because a lawyer will help you to write a will that is valid. Because we're talking about a will being written down, being reduced into writing, but not any document you have written may qualify as a will. You may think you have left a will, yet you have left just a document, because it does not fall within the ambits of the law, because there are certain key requirements of a valid will. That's why it is very, very important that even if you write it down, you consult a lawyer. Go look for a lawyer, say, is what I've put down correct? Is it valid? Can it be sustainable after my demise? Otherwise, you leave a document which we are going to come and challenge. We have had scenarios where all the parties agree that actually that is the handwriting of our late father. But when it is not a valid will in law, that means you cannot enforce any right of succession in respect of a will which does not meet the key tenets or the key ingredients of a valid will. So to sum up your question, you can write down, you can sit down and write your will. But if you want, you can hire a lawyer to prepare for you a will. And as I said, I strongly advise that for you to be really confident that what I've left down is a valid will, seek for the opinion of a lawyer to help you prepare a will, a valid will.
Yes, that's great. And what are those key ingredients that someone needs in order to make his will valid in the eyes of the law? What are those key elements he should include when he's writing?
First of all, I said for a will to be valid, it must be in writing. Many people come and, especially when we're in court, someone tells you, my father said this, but you ask him, did he write down any document? He says, no, but that is what he has already said. And people should differentiate between a will and a gift. Some people, especially parents, give gifts during their lifetime. and they write a document, let's say, I'm giving you that piece of land, and they write it down. That is not a will. That one is a deed of donation, because he has given you this property during his lifetime, and you have taken over, you have taken possession of that property. But for a will does not take effect until after the death of the person. That's why we always advise, actually even the law requires that the beneficiaries of the will should not see and know the content of the will. Because you never know if someone sees the content of the will. Some people have not prepared their children, but they say, we have prepared for you. Now, you prepare a will, you bring your children together, you tell them, this is my will, I've given you a plot in Zambia, I've given you a plot in Muyenga. But you, the testator, a testator is a person who has made a will. The testator, you are not dying. Remember, this son of yours knows that the property which is located in Muyenga is his property. And this can only happen when this father is dead. What may happen? So we find that some parents may face challenges of being eliminated by the children because they have known about the content of the will, and you, the testator, you are not dying for that person to be able to benefit from the will. So it is advisable, and it is a legal requirement, that the beneficiaries in the will, first of all, they should not be witnesses to the will, and they should not know the content of the will. So if you are to consider a will valid, it must have a date. Why do we emphasize the issue of a date? Because at one time, two people bring wills having different content. So they will say, which one is the valid will? Two wills. Actually, you can even write two wills. You can write a will today and then write another one tomorrow with different content. But legally, the later date is considered as the latest will in case of any contradictions. That's why we always emphasize that any will must have a date. Then number two, you must include your names as the testator. As I said, the testator is the person who makes the will. The testator, you must include your name. Who are you? In most cases, people talk about their background. Who are you? Who are your parents? Are you married? How many children do you have? Do you have a wife? Are you legally married with that wife? Why am I talking about that? Because these beneficiaries have rights, and these are legal rights. If you have a wife, include it that I'm legally married to so and so. We probably wedded in Zambia church. Why? Because not every woman you are having is a beneficiary to your estate. Okay? Because some people may not be legally married but staying with the husband. So you may not have the rights of a legally married woman. That's why the will must always clarify that I have a woman, but we are legally married. We got married in this year. So you include all that information. You name the children you have. And please, if you're making a will, include all the children you have. Some people fear to include the children who are born out of wedlock.
It happens.
Yes.
So can someone lock out their children from his will? I'm writing my will and I decide that I don't want to include my children. It will be
challenged. It will be challenged if you include and if you leave out certain beneficiaries. There is a will I'm challenging in court currently. The testator included a few children, and the rest were not given at all. Were not given anything in the will. So we are challenging that will. First of all, we believe that it was fraudulently prepared, because the father who loved all his children could not leave out the rest of the children. So we are challenging that will. And if you leave out your children, that will is likely to be challenged for having left out the beneficiaries. So that's why I'm emphasizing that when you prepare a will, list all your children. List even all those children that people don't know. After all, by the time they read them, you'll be dead. You know, some people fear to get ashamed that for me, I've been known as a very good man, but they have children outside. The law does not discriminate between children born in marriage and children born outside marriage. The law looks at them as children. And actually, even in the church, have you ever seen a priest or a parish priest saying that I'll not baptize that child because that child was born out of wedlock? No. All children are considered children. And actually, we consider children as gifts from God. So children are not responsible for the wrongs of the parents. If parents are not married, these are children and they're entitled to all the succession rights, irrespective of whether they are born within the marriage or outside marriage. Then the other aspect that normally comes, they say, oh, someone who is not from a legal marriage does not become heir. Again, that is also a mistake, because you are free to choose your heir. You are free to choose from any of your children who is going to be your heir. So name the children, and as I said, include all the children. You can even go ahead and give the details of your children, the age, where they stay, such that you still avoid the challenges of saying, oh, you are not our father's child. Today we are having challenges of DNA. If your father has named you in the will and included you in the will, who is going to come and say, you are not our father's children? So this one helps us to avoid conflicts after we have died. So that is one of the key issues we consider why someone should prepare a will. So include all the children. I said include the children, include the wife. If you have a wife, include the wife. Include what we call other beneficiaries. Their beneficiaries, we call them dependent relatives. Dependent relatives are not your children, but they are people you are looking after. People who are there because of you. So, today in Africa, we have extended families.
Family settings.
Yes.
We have that everywhere.
Yes, we also have people who are looking after children of the deceased brothers, deceased sisters. We are looking after our parents. Yes. And this parent is dependent on you. Those are dependent relatives. So if you want them to be catered for after your demise, include them and show what do you want them, how do you want them to benefit from your estate when you have died. No one is going to challenge that, because what you are writing in the will, it is you. That's why it is called a will. Your will. What is your will? What is your wish? It is your wish. But as I said, your wish must be legal. You cannot wish that for me, because they said you can prepare a will, I should be buried at Uganda Catholic Secretariat because it is your wish. Uganda Catholic Secretariat is not yours. It's not your burial ground. So your wish must be embedded within the law. So talk about your children, talk about the property you have. List all the property you have. List all the property you have. And one aspect of challenging whether the will is valid or not, some people look out, there are some properties, if someone forges a will, they can leave out property of the deceased. Because if you have property, it will be very, very hard for you to forget your property. So list all your property. Someone will ask that if I write a will and I've included my property, and I've signed the will already, but I buy some other property, what happens?
How do we address that?
Yes, the law provides for, we call it a codicil. A codicil is an addition to the will. It is more or less like if you have an agreement, you have written an agreement. When you write something to add on the other agreement, you don't write a new agreement. You prepare what we call an addendum. So an addendum is what we call the codicil in wills. So you also add, you say, this is an addition to my earlier will. You include whichever. If you wrote a will when you had 2 children and you have produced more children, then you can always add. You don't need to say, I'm doing away with the first one, then I prepare a completely new will. So you can always add progressively as you prepare your will.
That's good. Let's bring in this scenario. Imagine I write my will, I list down my children, my legally married wife, the extended family, relatives I'm supporting, and I even list down the reasons that upon my demise, I'm ceasing support to you. Can it also be challenged? Like if I cease support to the extended relatives I'm supporting, or to 1 or 2 of my legally listed children in the will, is that will challenged, that it's unfair?
Yes, it can be challenged. It can be challenged. You must justify why you are not giving a certain beneficiary in the will.
So if I justify that reason,
yes, you must justify, and it must be a valid reason. There is a will I'm also challenging. Actually, it's not even a will. This one did not make a will, but other beneficiaries are saying that no, that brother of ours is not a beneficiary because he was disowned by our father when our father was still alive. But remember, this father did not leave a will. It is not written anywhere. So how do you prove that the father, before he died, he had disowned? And what is disowning in law?
So
what is disowning in law? Actually, the law does not provide for disowning children.
It doesn't provide.
No.
So how do you deal with the issue of disowning one of your children? Imagine he's not biologically linked to you, he's not your real son. So how do you deal with that scenario?
Then that one is, you see, that one takes us to the current issue of DNA.
DNA testing.
Yes, you do a DNA test to prove whether this one is your child or not.
So if I find out that he's not my child and I'm writing my will to note that I discovered during a DNA test that
you don't include him. You don't include him.
He has no right to claim my assets.
No, because who is a beneficiary to the will? I mean, to the estate. The beneficiary to the estate are the people named in the will in the first place. If whoever is named in the will, whether is a child or not, as long as someone has been named in the will, is a beneficiary to the estate. I told you that it is called a will. You are free to distribute your property as you want. You are free to even say, I've given my children this, the rest of the property I've given to the church. No one is going to challenge that. I'll try to refer to some of the cases I'm handling. There's a case where someone has given land to the church when he's still alive. But the children are saying, no, how would you donate our land to the church? That one cannot be challenged because, first of all, this father is still alive, and children do not have any right over their parents' property when they are still alive. So in the will, that's why you always advise, prepare a will. A will will help you to even distribute your property equitably, not equally, but equitably.
Yes.
Why do I say equitably? Because you'll find that there are those children who have not looked after you. There are those children who have not been there for you. There are those children you have given during your lifetime. Yes. There are those children who have not received at all. So when you're writing a will, you may consider such issues, that this one has really been there for me. This one has provided treatment. This one has, whenever I have a problem, this child comes. So you distribute according, that's why I'm saying equitable distribution, but not equal. When you're writing a will, you are not mandated to distribute equally. But when you don't write a will, then that property will be distributed equally. The law will distribute that property equally among the children. Yes. So what is safer? It is safer to write a will. People fear to write a will. Someone thinks whenever you write a will, you're dying tomorrow.
That public perception.
Yes, that the moment you say, I'm writing a will,
why should I write a will?
I'm dying. But how many people have died without wills? Have they died because they wrote wills? Actually, there are more people who die without wills. I was doing a training on will writing somewhere. Then this man asks me that, how about if I die abruptly without writing a will? What will happen? Then I asked him, how old are you? He said, I'm 68. So you're saying at 68, you are telling me that at 68, you have died abruptly. Where have you been from the age of 18 years? Because I told you, you are free to prepare a will from the age of 18 years. I think this matches very well with the theme of the program, responsible citizenship. That a responsible citizen must have a will. A responsible citizen must have a will, must die and leave behind a valid will. So, include your children, include your property, and the property should include, it should be your property. Don't include the property you have sold already. Don't include the property you have given away. That brings about contradiction, because that will be challenged. Because if you have sold to me property, or if you have given me property, and then you include it in the will, I'll file a suit and challenge that provision, that the property, the land in Zambia, which is included in the will, was given to me by my father before he died. Therefore, it does not form part of the estate of my father. So it should be pulled out of the estate, because it was given to me during his lifetime. That is what we call a gift inter vivos. Gift inter vivos. It's a gift during the lifetime. So, further, another thing you need to include in the will, you include the executors of the will. The executors, you can include, you can say an executor or executors in the will. The executor is the person who puts into effect the will after your demise. And this executor can be any person. You get someone who is responsible, someone you believe will be able to implement your wishes without any influence. Someone you bring will have authority. The authority I'm talking about, not the authority of power and command, but the authority of respect. That the family will respect him to be able to implement your wishes. Who is an executor? An executor can be one of the children, one of the beneficiaries. Okay, you can say my firstborn will be the executor of the will. You can say my friend who is a priest will be the executor of the will. It doesn't mean that the executor is a beneficiary to the will. His role is to put into effect the wishes. So you name the executor. And once you name the executor, that means there is no any other person with authority to deal with your estate, unless unless this executor renounces. Renunciation means that you read a will, and probably they have named you as an executor. You say, no, I will not handle those issues. And you... Yes, you renounce. You say, yes, you say, I'll not be able to handle those issues. We normally prepare what we call a renunciation document, a deed of renunciation. You sign, you say, I'll not be able to handle the estate. Then the family will be given responsibility to identify administrators of the estate.
Let's bring in this scenario, like I heard about it in Amoro district, whereby, let's say, my great-grandparents gave away land to establish a Catholic founded school, primary school or secondary school, but they gave it out verbally. Right now, the descendants of the grandparents that gave out that land start claiming part of where the school has been built. How is the Uganda Episcopal Conference trying to address that? Because it has started cropping up. And remember, most of the that giving of the land, it was verbal. A great grandfather comes out and says, I'm giving this portion of land to the church, build for me a school to train and support. But right now the descendants are challenging. They want to claim the land that has been given to the school.
And there's no document.
There's no document. That's
this. I'm addressing this, and I've addressed this to the church several times. That let us insist on documentation. Let us insist on documentation. Many people have donated land to the church.
Yes.
Verbally. And the church has taken over that land.
Yes.
When these people are still alive. But as you said, eventually these people die. And the so-called beneficiaries come and say, no, for us, we don't know about the donation. And actually, it will be very, very hard for you to say I was given without any documentation. So the only way to remedy this is that whenever you receive, when you talk about responsible citizenship, we are talking about responsible citizenship, even within the church.
They have to take the initiative to document.
They have to take the initiative to document. Let them use, dioceses have lawyers. Once a parishioner comes and expresses interest to give land to you,
all land that has already been given.
All land that has already been given, please have the documentation. Put that in writing, prepare a deed of donation, let the person responsible sign. And for us in the church, the person responsible, we have the trustees of the diocese. They are the custodians of the diocesan land, headed by the bishop. So let them prepare these documents, and we are embarking on that process of making sure that we streamline the properties, we protect the properties of the church, especially the property that has been donated to the church. I want to wind up the key ingredients of the will. Probably when we have some other time, we shall be able to continue. I said include executors. There must be executors. Heir, name your heir.
Name them all.
The heir. Who is going to be your heir? Who is going to be your heir? Name the heir, because the disputes that arise when you have died, who is the heir?
Who is the heir?
Yes. So write the heir. Who is the heir? No one is going to challenge that, as long as it is a valid will. There is that clause as you begin the will. You say, I'm of a sound mind. We call it the state of your mind. You include that I'm of a sound mind and have not been coerced or forced to write this will. Some people force people who are on the deathbed to prepare wills. That will be challenged because this person is not doing it out of free will. And you don't know the state of the mind at that time. So do the will when someone who prepares the will, someone who writes the will must be of a sound mind, a stable mind. But it is allowed, you may be sick today, dying, then you stabilize. So it is allowed that during that process, when you have stabilized, yes, you prepare your will. Then no one will say, but this person has been very sick. But there are moments when this person stabilized and he was of a sound mind. So after preparing your will and you have put all the content you wanted, sign the will. The current Succession Amendment Act requires that if you have written 10 pages of the will, sign on all the pages. If you have written 5 pages, all the pages at the end of the paper, that is where you put your signature. So make sure you sign the will. If you cannot sign, put a thumb. We call it a print, a thumbprint, a mark. And when you put a mark, you will normally advise people that indicate which hand. Is it the right or yes, yes. So after you have signed your will, or after you have put your thumbprint, you must have 2 witnesses to the will. You must have not 1 witness, but 2 witnesses
to the will.
If you present a will with 1 witness, it will be nullified. If you present, the law requires 2, at least 2. You can put 10.
There's no problem.
You may put 10, you may put, but at least 2, a minimum of 2 witnesses. And these witnesses, this is also very important. These witnesses must be present at the same time. They must see you sign. Because remember, these witnesses are not witnessing the content in the will. They witness your signature.
Your signature.
Yes.
So it shouldn't be online. Let's say you're video conferencing and you call them at the same time that I'm writing my will. And how does the
law requires that they must see you, but because of
technological advances.
Yes, it is. They can see you. They saw you. It is allowed to. Today we are doing things electronically. What the law requires: did you see this person sign? You appear before me, you appear in court and ask this person, where did you? He said, no, someone brought it and I signed it. That one alone invalidates the will because you did not see that the person sign. So the viewers should know that it is not enough for you to go in your bedroom, prepare, then send a copy to so and so. Say, please sign. No, these people are witnessing the will. They're not witnessing the content, because if you have named 10 children and this person knows about 5, is he going to say, I'm not signing because I'm seeing some children I don't know? No. You have written some properties. Is this person going to ask you that before I sign, you take me, I see all the properties you have? No. So they're not in the will. A witness is not witnessing the content, is witnessing the signature. So without a signature, a will is invalid. If it is only your signature without witnesses, a will is invalid.
So, Mr. Frederick, how should we change people's perception on the need to write wills? How should the audiences listen that, please, if you're 18 years of age, if you have something or don't have, why should they write a will? That perception, how should what should we do to change that perception?
One, we have to do a constant sensitization, constant reminder, and even to help them. Because someone will say, I want to write a will, but I don't know how to write a will. To even accompany people who like to write wills. And the other aspect is to emphasize the importance of writing a will, because you have made you have worked, accumulated property, but this property will go in disarray when you die because you have not left a will.
And that cultural perception whereby they say you shouldn't count your children or name your assets, it's also common. There is that cultural clash.
But when you're writing, you're writing this will alone, so no one is counting for you the children. You sit down and write the number of children you have. But as I said, the life of a human being rotates between 2 legal documents. One is a birth certificate, another one is the death certificate. So in between there, what will govern the life after your death is the will. So a will encourages, guarantees stability of your family. It guarantees coexistence of the family. It guarantees respect. Actually, what I've forgotten in the will includes your place of burial. Where are you going to be buried? Where do you want to be buried? To avoid going to court, for court to determine where you should be buried.
We've had that
yes,
case recently.
Exactly. We can avoid the scenarios of parties. These relatives are saying we are burying him here. Other relatives, even you have seen it, even live alone in the urban centers and among the civilized societies where people go to court for court to determine. But in villages, people fight for the dead body itself.
Yes, it happens.
People fight for the dead body itself, and they see people running away with the dead body because you did not leave a will, your body is going to be disrespected because you did not take this opportunity to prepare a will.
Another question comes in, after I've written my will, where should I keep it safe? Where should I keep my will safe?
Where should you keep your will? When you prepare your will, you can give it to any person you trust. You can give it to your friend. You can give it to your lawyer, if you have a lawyer, because after the lawyer is prepared, a lawyer can keep a copy. You can give it to a religious leader. You can give it to your parish priest. You go to your parish and give it to your parish priest to keep it. You can, some people, even banks keep these documents. But the challenge is the bank may not know that you have died. You should give a will to someone who knows about your life, such that in case of demise, in case of death, this person will bring that will. And when you give me a will to keep, give me instructions on what to do with that will. Some people give others wills for custody without giving them instructions, because the question the viewers should know that when do you bring it out? If you have been given a will to keep, when do you bring it out?
Yeah, that needs to be clarified.
Yes.
When do you bring out a will?
Yes, when do you bring it out? It is important that a will is opened after someone has died. Remember, you who has kept the will, you were not one of the witnesses. And even if you were one of the witnesses, you don't know the content of the will. So normally when someone dies, you go and call a few people, few responsible people in the family, and say, I'm so-and-so, I was given so-and-so's will to keep. So you open the will, and we call it peruse. You go through the will. You don't call the whole family that please come and we. Yes, a few. You say you can know the people. Yeah,
you can even know them.
You can know. Yes, you can know the people. It could be the clan leaders, because all those people always converge when someone dies.
Yes, they do.
Yes. So you go. You say I have someone. So they read it. The purpose of reading this will when you have just died is to know what are you saying about your burial. Because some people are very, very clear on what should happen, on what should take place at burial, and they include it in the will. So when you get a chance of reading it, you identify only those areas of the burial, or how should the burial ceremony be conducted, and where is he saying he should be buried. Otherwise, people, especially traditionally, they think or they believe that a will is supposed to be presented during the last funeral rites.
Funeral rites. That's the most common occurrence.
Yes, they bring it is on the last funeral rites that they say, who has a will? Who has a will? No, a will is presented when someone has died. That's why I'm advising that if you are the testator and you have given someone to keep custody of your will, give him instructions that in case, you always say that in case I die before you, because we don't know, we don't know who will die first, because I can give you my will to keep, but you die before me.
The executor.
Yes. You will find that executor has died before the person who has made a will. That's why I'm going.
Also need for that contagion.
Yes.
In case the executor dies.
That's why you should give copies to different people, at least two different people.
Yes.
Give copies to different people to keep, and give instructions to these people that if the Lord has called me, please give this will to so and so. You can even be specific that you hand over this document to so and so, or you go and look for, if they have not given you specific instructions, then you go to the family and find out. You already see people who are responsible, and hand over that will. Open it, as I said, I caution you, don't read it to the family members.
No.
Because you'll find that the will, as it is, it has distributed property, but some people feel they would have been given more.
It happens.
Some people feel the will is unfair. Those people are likely to even walk away.
It's bound to happen.
Yet the purpose of the will is to bring about harmony when you have died. So those people are likely to walk away. If you are going to bring about chaos at your burial. If you say, please read my will before everyone, and some wills, I'm telling you, some people write wills which embarrass people who have stayed behind. Some people can write all his grievances in the will, especially as between husband and wife. And some things cannot be read in public.
Yes.
So people should be very, very, very cautious that peruse, look at the will. Then you can always look into the details of the will a few days after, after burial.
When the emotions are
Exactly. So to sum up your question, you can give any person you trust to keep the will, but give that person to keep the will with clear instructions on what to do with the will after your death.
Yes. Finally, your final thoughts on the topic of wills. What does the TV audience need to know? What should they keep in mind as we will come back again?
Yes, my final remark today is that people should not fear to write wills, because with or without a will, we shall die. Because as I said, some people fear to write wills because they say maybe the spirit is telling me that you're about to die, please write a will. No, please prepare a will. You can periodically update your will. It will give you rest in peace. You rest in peace. And you'll also, some people have properties which are not known to their children and wives. And these properties disappear because after your death, you have not named where they are. I'm stuck with land titles for one of my clients who died, but no one is coming to claim for those titles. He died, and it is not clear on who is the owner of those properties. You see, just because there was no clear document of saying this document is for so-and-so, this document is for so-and-so. So that's the importance of writing a will.
Does the law also provide for that in case the person who has written the will has died with properties unmarked? How does the law address that? Does the law reach out to the family members and notifies them that I have this property?
Yes, that's why when you are looking for a lawyer to work for you, look for, this is responsible citizenship. Yes, you also look for a responsible lawyer. Okay? Look for a responsible lawyer who will be able to protect your assets, who will be able to make sure that whatever belongs to the beneficiaries reaches the beneficiaries. Yes. So that matches with responsible citizenship. Responsibility cuts across to even identifying a good legal person who should work for you, a trustworthy advocate who should work for you.
Yes. Thank you very much, our dear guests, Mr. Frederick Ssemwanga, Parliamentary Liaison and Advocate with Ssemwanga and Muwazi and Company Advocates, for this interesting take on the need to write a will. It begins with you, and this is from us, from the Responsible Citizen. Thank you.